and operating, our Chief Operating and Legal Officer here at Wood System of Care. And Cy is going to go in and talk to you about professional malpractice. So Cy, whenever you're ready, take it away.
All right. Thank you very much, Christina. Appreciate the opportunity to share some thoughts with you today. We're going to stop a few minutes early to give you the opportunity to ask some questions. I'm not going to follow the PowerPoint precisely because you can read the PowerPoint on your own if you care to. And it is kind of a bare bones introduction. I understand that this is somewhat different than the grand rounds that we have been offering. I'm not a healthcare professional. Work with you guys all the time, but I'm not one. But I do encounter and deal with malpractice and healthcare related issues enough where I thought to take a break from cell biology and various pathologies that you might be used to talking about in the grand rounds. A discussion of something like this might be worthwhile and interesting. Hopefully it is, although I've been wrong before. Let me tell you where this idea of making this presentation comes from. I don't think there is a professional out there, and whether you're a healthcare practitioner, a lawyer, an accountant, or so forth, who does not have in the back of his or her mind the possibility of being hit with a malpractice suit. Although many will go through their professional lives without that experience, enough have where a discussion as to how it happens and what happens after it happens is probably worthwhile. So first of all, let me talk to you a little bit about what malpractice is and how it fits into the general landscape of legal liability. A definition of malpractice, and there are variations of this definition all across the country, is a failure of a professional to act in accordance with prevailing professional standards or failure to see the consequences that a professional person having the necessary skills and education can foresee. In Pennsylvania, it's a negligent or unskilled treatment by a healthcare professional, in this case, medical malpractice, that deviates from the accepted medical care standards and results in injury to the patient. Malpractice is a subset of something called professional liability. Professional liability, for example, is what exists in the everyday world. In, if you have an auto accident, if you slip and fall, sometimes if you have a medical incident that does not involve a professional, for example, a hospital, that's within the under the rubric of professional liability. So professional malpractice is a subset of that. And it's generally acknowledged that there are 4 elements of malpractice. And you don't have to take notes on this and there won't be a test, but when you think about it, it kind of makes sense. First of all, in order to be the subject of a malpractice suit, you have to owe a professional duty to a patient. Second, you have to breach that duty. Third, that breach, that failure to act appropriately, has to result in injury. And fourth, there have to be damages to the patient resulting from that injury. And if one of those elements is missing, you're not going to have a malpractice case. Now, there are some misconceptions about malpractice and professional liability and liability generally. All of those fall within a subset of the law called a tort. And a tort is a non-contractual wrong, civil wrong, not criminal, civil wrong, for which there is a remedy in the courts and that does not arise out of a breach of contract. Now, as a result of this overview I just gave you, you now have successfully completed the first year law school course in torts. So let me move on from there. Why do we talk about professional malpractice in terms of different states and different parts of different states? The one thing that's kind of unique about our federal system of government is that there's some areas of the law that are really confined to or dictated by states, not the federal government and not localities. Divorce law, for example, that's a state issue. There are state laws, state courts that deal with divorce, not federal courts. Same with malpractice. Same with, in most cases, professional liability, but I won't get into that because there are exceptions there. But professional malpractice is a state court and state law issue. So malpractice looks different in Pennsylvania than it does in New Jersey. Malpractice looks different within Pennsylvania, whether you're in Bucks County or whether you're in Pike County or whether you're in, God forbid, in Philadelphia County. And it looks different in New Jersey if you're in Salem County or you're in Essex County, which is newer. How are they different? And how are they the same? Let me talk to you a little bit, and this is in the outline, about what lawyers talk about when we talk about venue. And I know I'm skipping around a little bit, but there's a lot to cover in a short period of time. We know that we're talking about state law involving malpractice and professional liability, not federal law. And we're talking about what happens within each individual state. Well, there's some commonalities, right? First, in New Jersey and Pennsylvania, which are the states that we'll talk about, both states require that physicians and hospitals, facilities, must have malpractice insurance. Not every state requires that. Pennsylvania and New Jersey do. The current minimum requirements are $1 million per occurrence, $3 million in the aggregate per policy year. New Jersey does not have a system or a fund set up that goes beyond basic malpractice. It attempts to protect practitioners who are in nonprofit settings, such as Woods, from excessive liability through something called charitable immunity. If you work for a nonprofit sued, you're sued as an employee of the nonprofit. Something beyond mere negligence has to be shown in order for a plaintiff to recover. That provides, in fact, very little protection. In Pennsylvania, there's no such protection. In Pennsylvania, if you're a healthcare practitioner or you work for a nonprofit, which most hospitals are, which Woods is, you get no additional protection. Matter of fact, the Pennsylvania courts have said just because you work for a charity doesn't mean you don't commit malpractice. But in Pennsylvania, they have something called M-Care, which does provide an additional layer of malpractice coverage that covers the practitioner at a cost and also provides additional layers of recovery to a plaintiff. Question sometimes arises. If I'm sued for malpractice, it's pretty much the game's over, right? The answer is wrong. That's not the case. It is still true. And while hard statistics are hard to come by, it is still true that most medical malpractice cases that are not settled before trial, that there is at least a 50-50 split between verdicts for the defendant, meaning no liability found, or a verdict for the plaintiff. And if the plaintiff is found to be to have contributed to the problem, that will often reduce the amount of the reward. Now, ignore what I just said. There are places in Pennsylvania, and I'm going to concentrate on those, that are known as, quote, judicial hellholes. What do I mean by that? You've probably heard the term. A judicial hellhole, first of all, is usually so labeled by organizations that don't like plaintiffs' lawyers. But judicial hellholes are places where you don't want to be sued if you're a professional, whether you're a lawyer, doctor, or whatever. Why? Because juries in those jurisdictions tend to give very high malpractice awards if they decide that a defendant is guilty. And in certain circumstances, with high risk specialties, neurosurgery, for example, vascular surgery, obstetrics, the awards can be very high, and the awards against the hospital or entity where the physician is on staff can be very high. That's sometimes called the angry juror syndrome. Sometimes those multi-million-dollar awards are called nuclear verdicts. And they tend to emanate from places like Philadelphia, which is notorious nationwide, along with certain places in Georgia and elsewhere, where the juries tend to want to send a message. And they want to send a message in those jurisdictions often because their intention is to punish, not necessarily to award compensation, although that's a key part of it, but to punish the practitioners and punish the institutions and send a message. Those nuclear verdicts are starting to pop up outside places like Philly. But we spend a lot of time at Woods, frankly, when we're sued for professional liability, almost never for malpractice, because we're not, most of us who work here are not physicians and healthcare practitioners. We tend to try to avoid being placed in Philadelphia, having the case venued in Philadelphia because of that risk. But there are places now outside of Philadelphia, including some of the so-called collar counties, Delaware County, Montgomery County, a little less in Bucks County, where very high verdicts are also popping up. Also in places like York County, bizarre though that may seem. And you're having some very, very famous physicians and institutions get hit, whether in Philly or elsewhere, for high verdicts. There was one not so long ago against the University of Pennsylvania Health System. With interest, that verdict is going to go over $200 million. Temple, $40 million. That was just overturned, but it's likely to be reinstated. So some of the stories you hear about judicial hellholes and avoiding Philadelphia and so forth are true. If you're sued for malpractice, though, what are the chances that you're going to go to trial? Slim. Most malpractice cases, like most liability cases, are settled before trial. No one can come up with a hard and fast statistic, but I have heard that 90% or more of cases are settled before trial because nobody wants to take a chance on either getting a huge verdict against you, or if you're a plaintiff and a plaintiff's lawyer, getting nothing. So the system is geared to try to settle cases. Who has the burden of proof in a malpractice case? What does a doctor have to show? What does a plaintiff have to show? The burden of proof in almost any civil case, including professional liability, professional malpractice, the burden of proof is on the plaintiff. The defendant is not required to prove that the defendant is not liable. The plaintiff must prove by a preponderance of the credible evidence in the record that malpractice has occurred and damage has occurred as a result. What do lawyers mean when they talk about preponderance of credible evidence in the record? Well, that's the lowest evidentiary standard there is. You all know from watching various TV shows and perhaps from personal experience that the highest standard is beyond a reasonable doubt. That's in criminal cases. The clear and convincing standard, which is often in regulatory cases, is a strong likelihood that something has happened, a mistake has happened, that the charges are true. Preponderance of credible evidence is more likely than not. And that's all it is. More likely than not. So how do you build a defense around more likely than not when a plaintiff comes in to a courtroom severely damaged as a result of a medical procedure, which may or may not have actually been the fault of the defendant, but they come in, their lives are ruined. What defenses are available? Well, the one thing that both Pennsylvania and New Jersey and a lot of states have required is something called a certificate of merit. In order to even bring the action and maintain it, you have to produce an affidavit or certificate of merit from a physician or healthcare practitioner that says that malpractice was committed in that person's opinion, and that person has to be qualified by education and experience to make that judgment. And without a certificate or affidavit of merit, your case is dismissed. So that is one safeguard for the defendant. But that only takes you so far. Here are some other safeguards or pluses that assist the plaintiff. First, malpractice doesn't necessarily have to be all that hard to prove. There are things that leap out off the page. One of the things that you may hear about or have heard about is one of the few things left of law Latin that I learned when I was in law school. It's called res ipsa loquitur, or a res ipsa case. What's res ipsa? It means in Latin, the thing speaks for itself. A res ipsa case in medical malpractice means that the occurrence is so clearly wrong that further proof is unnecessary. What's the example that's often used? In surgery, somebody leaves a surgical instrument or a sponge in the surgical area and sews the patient back up. Sponge shouldn't have been there. Instrument shouldn't have been there. Malpractice insurers, get your checkbook out. Iatrogenesis. It's a term that I think all healthcare and clinical practitioners know. It's doctor-created disease. Medication errors that result in obvious damage and injury. Failure to diagnose timely. Big issue in cancer cases. Failure to treat. leaving a patient in the ER for hours at a time without monitoring vitals or paying attention until the patient codes. Conspiracy of silence. You don't hear that term as often, but that's where you got lots of physicians, nurses, practitioners, variety of specialties, all in an operating theater. Take an extreme example, patient dies on the table. Nobody says a thing. Conspiracy of silence. Guess what? They can all be held liable. Because silence in a civil case, unlike in a criminal case, unlike in a Fifth Amendment case, can be held against you. Okay, so I've either bored you or scared you. What's the point that I want to, or points I want to come away with here? First, and this is maybe a political statement on my part, I think the awards in malpractice, while objectively should be criticized, also result from a reaction of jurors and sometimes judges, because not all these cases are tried before jurors, that the plaintiffs need to be compensated and taken care of for the balance of their lives, for the deficits that they have incurred, because there is no safety net here. Because this country does not do a good job taking care of people who are most in need. And therefore, the tort system, remember, malpractice is a subset of a tort, exists in an attempt to plug massive holes in the safety net. And as long as that safety net is not relatively strong, the alternative to taking care of people who are severely injured falls on the private sector. In many cases, on insurance companies, which pay the bills. So other countries, and we're not going to get into this today, don't have time, handle malpractice awards and malpractice issues very differently than we do in the United States. And there's a reason for that. So when I hear friends of mine, and many friends of mine are physicians, complain about the malpractice system, even though I don't think any of them have been sued, or most of them haven't, sometimes it's important to remind people that there really is no societal alternative that makes sense. And other countries have those alternatives. Skipping around a little bit, are there things that we talk about when we talk about risk and how to mitigate it and lessen it that are practical remedies that sometimes it's easy to forget about? What do I mean by that? First of all, it sounds so obvious, it's stupid, but I've been accused of belaboring the obvious and saying stupid things, so you'll forgive me. Don't do stupid things. Don't leave sponges in patients. Don't neglect a patient for hours on end who happens to come into the ER. Listen to your patient. Listen. And that's hard to do because any of us who've gone to the doctor recently or healthcare provider, PCP, what do we see? Well, for the most part, we keep all our clothes on. Very few tests are done. The doctor or the doctor's assistant or the PCP or nurse practitioner stares at a computer screen, inputs into the electronic health record, checks up on your medications. If you're above a certain age, once a year, it gives you a amazingly dumb test to see if you're senile. We're getting there. And spends, if the appointment is for 20 minutes, 5 minutes listening to you. And it's not their fault. The fact of the matter is that that's all the time they have. But where you can make a change, where you can listen, take a few extra minutes, you do it. You listen to your patient. And that's something of a lost art. A good friend of mine is a cardiologist. Like most or many specialists, he sold his practice to a hospital. At least he didn't sell to private equity. The hospital said to this group of cardiologists, size of a law firm, you can spend 20 minutes with a patient. Cardiologist, subspecialist. Well, he deals with older patients, complicated patients, patients with heart failure, patients with all sorts of issues. And he probably spends 40 minutes with them. So his office gets backed up and he gets penalized. Fair? Nope. Way of life for many people who are probably listening today? Yes. So to the extent that a physician or practitioner can push back against a system that's designed to squeeze the life out of them, they ought to. So the first thing is listen. Second thing, if you screw up, apologize. There have been studies. There's a fairly well-known study that goes on and on. I read it a while ago. What's the difference between the amount of a malpractice award or even the bringing of a lawsuit against practitioners who admit they're wrong, as opposed to practitioners who are arrogant, defensive, or don't talk to their patients or talk down to their patients? The results were remarkable. The practitioners who owned up to their mistakes, they had to pay, but they paid in many cases a lot less, remarkably less than the physician or the practitioner who stonewalled. And often a settlement was arrived at, a fair settlement to both sides, the injured patient or its family and the practitioner, without the need for any litigation. To say that I'm sorry, it shouldn't have happened. It's a very difficult thing for highly trained practitioners to do, whether you're a lawyer, a physician, whatever. But studies have shown if you can swallow your pride and admit the mistake, you're going to be better off. And frankly, your patient will be too. What are some other things you can do if you're sued? And remember, keep in mind that most physicians and healthcare practitioners will not be sued. In most cases, if you're sued, the suit can be dismissed or settled before trial. And then if you have to go to trial, unless you've really screwed up royally, you have a decent shot at winning. So what are some other things you can do? We've talked about listening. We've talked about admitting you're wrong. We've talked about really or we haven't talked about, but making sure your patient understands and appreciates the risks and rewards of what is going to happen in the OR or at some procedure. And offer and don't be offended by second opinions. The more a patient knows, the better off you're going to be and the patient will be. And these release forms, these consent to treat forms that frankly, I prepare and the other lawyers prepare here, they are not going to get you off the hook. The fact of the matter is that the patient has to understand, as a reasonable person would understand, what the risks and rewards of a given procedure or surgery or course of treatment will be. So what's the end result of all this? How do healthcare practitioners protect themselves? And how do we deal with a system that is designed as a substitute for a safety net and that recognizes that people who are injured deserve to be compensated? There have been all sorts of solutions proposed to dealing with what some people call a crisis. The first is something as simple as make sure you don't practice in Philadelphia. That's probably, if you take anything away from this presentation, that's the one thing you should take away. And I'm only being semi-facetious. Penn, Jeff, and so forth, they can't help it, and the physicians who work there. But there is an exodus out of Philadelphia in terms of avoiding the jurisdiction of the Philadelphia courts, and it is what it is. Some of you may have heard of attempts made from time to time of the placement of caps on awards. There was a movement many years ago when the insurance companies claimed that they were losing money on malpractice coverage. And physicians were truly petrified at the malpractice landscape. There was a movement afoot to put caps on pain and suffering. Now, what does that mean? And why is that movement pretty much a failure? No one really argues that there shouldn't be compensation for someone who was grievously injured by malpractice. There is general agreement that economic damages should be awarded without limits. If someone can't work anymore, if someone's a dentist and loses the ability to use their hands. But there has always been debate as to whether damages should be awarded for non-economic suffering, pain and suffering, loss of consortium, and so forth. At one time, there was a view that punitive or a cap on punitive damages. In other words, no cap on economic damages, either a cap on punitive damages or a cap on non-economic damages. And you heard sometimes 2x. In other words, if the economic damages were $250,000, the punitive damages or non-economic damages should be no more than $500,000. Some states have enacted caps. The problem with caps is that they don't recognize what happens when, to take an extreme example, a surgeon removes the wrong kidney or amputates the wrong leg. There is no, under that system, there is minimal, if any, compensation available for the attendant damages that are not economically, directly economically involved. And the real reason that the plaintiffs' bar, labor unions, and so forth strongly resist caps is because if the caps are low enough, who is going to represent plaintiffs who are injured? In Pennsylvania, there is no limit on the amount an attorney can charge for bringing a malpractice case, or with some minor exceptions, almost any case. If the amount of damages awarded is so small and the amount of preparation and time and effort and money is so large in terms of bringing a case to trial, who's going to bring it, regardless of the percentage that they could get? And in Pennsylvania, the going percentage for bringing a malpractice case is around 40% of the recovery. And that's a contingent fee, which means if you don't get anything, if there's no award, you don't get paid anything. In some ways, it's even worse in New Jersey if you're a plaintiff's lawyer, because they have caps, percentage limits on how much you can be awarded, absent order of the court, which my understanding is you almost never get. You never get an exception to the percentage rules. Again, what kind of incentive is there? So these types of controls, certificates of merit, caps on pain and suffering, and so forth, really are band-aids that don't go to the core issue of why people bring malpractice cases and why, in many cases, they recover. But here's one thing you can do, and then I'll be quiet and see if there are any questions. I have about 5 minutes, I think. One thing that's totally unrelated, you would think, to anything I've talked about. In Pennsylvania and in many other states, we elect our judges. Think about that. Do you know anything? And I don't mean to say this in a negative way. Do you really know any, when you go into the ballot, the voting booth or vote at home, do you really know anything about the people running for judgeships that you're expected to vote for or against or to retain as judges? You don't know anything about them. I'll bet you anything. If you're a Democrat, you probably vote for the Democrats. If you're a Republican, you vote that way. Many judges cross-file both parties, so you don't know who you're voting for. There is no party affiliation. And then in Pennsylvania, the judicial terms are 10 years. So at the end of 10 years, the judges can step aside, or if their parties like them, they haven't offended too many people, they can stand for retention, which means you keep them on or you kick them off. What are voters supposed to know about the judicial records of judges who have been on the bench for 10 years and are looking for another 10-year term? But here's why the system hasn't changed in Pennsylvania. Because there are vested interest groups who want to keep the system because they know very well who's running for the judgeships. And they know very well what their positions are with respect to dealing with issues such as malpractice. And so the system stays in place. So one example of how this works, and this is an editorial comment, so take it for what it's worth, is that for many years in the early 2000s, we had a rule in Pennsylvania where malpractice actions could only be brought in the county where the injury allegedly occurred. So if you were being treated up in Potter County at the little hospital there, and they committed an injury, you could only sue there. The hospital and the physician could not be sued elsewhere in the Commonwealth of Pennsylvania. A couple of years ago, the Pennsylvania Supreme Court changed that rule. And they reverted back to the rule that a defendant could be sued basically where the action occurred, where the wrong occurred, or where the plaintiff has a presence, or the defendant has a presence. They could be sued anywhere, basically, as long as the defendant had some connection with some place in Pennsylvania, and the connection could be very tenuous. So guess what? There's a rush to file medical malpractice suits in what county? Philadelphia. What can you do about that? If you really want to try to make an impact, lobby your legislator to change the rules. When the Supreme Court justices, who also have to stand for election in the state, are up for election, participate, ask questions, go to voter education and get together places, and ask the question, why'd you change the rule? Why didn't you change it back? So if you really want to make a change, you can, fight for caps on damages, not likely to succeed. You can do all sorts of other things, join professional organizations, lobby, and that. But look at who the judges are, and look at where the lawsuits are being brought. There is less of a problem, frankly, in New Jersey. In New Jersey, judges are appointed, just like with federal judges, and approved by the state Senate. And there are a few mini judicial hellholes in New Jersey. As I said earlier, Newark is one of them. But for the most part, they're clustered in the northern part of the state facing New York, and are less of a problem throughout the rest of the state. When I say problem, I mean if you're a physician or representing them. Last point. There's a misconception running around that unlike other defendants in liability cases, slip and falls, auto accidents, you name them, that physicians and healthcare practitioners have a privileged position in that they can veto malpractice settlements. In other words, they're always defended by insurance companies. Remember, you have to have malpractice insurance in New Jersey and Pennsylvania. And if the insurance carrier wants to settle a suit, the healthcare practitioner can say, no, I insist you take this to trial. That's a myth. The fact is that for the most part, malpractice insurance policies are what are called first dollar policies. That means that the malpractice carrier pays from the first dollar on for defense costs and any damages that are awarded. And it's the insurance companies that call the shots, not the practitioners. One of the battles that we have here at Woods constantly is to battle our insurance carriers so that we have a choice of counsel to represent us. We usually win those battles, but not always. And then we have a back and forth over whether to settle a case. Physicians and other practitioners, like other defendants in liability cases, often are stuck with insurance policies where the insurance company makes the ultimate decision. And here's the kicker. A physician or a practitioner can say, I don't agree to this settlement. They can say that. But most malpractice insurance cases, policies, have something called consent to settle clauses. And that means that if you turn down, you being the defendant, turn down the insurance company's decision, veto it, to settle, the case goes to trial, and there is a greater award than what the insurance company would have settled for, the individual physician or practitioner, the insured, is liable for a significant percentage of that enhanced award. That comes out of your pocket. And that's called consent to settle or a hammer clause. So when you're getting in malpractice insurance, if you're interested, see what kind of policy it is and what the contents of those policies are, and whether, and you'll find it usually does, it has a consent to settle clause. As you can probably tell, I could go on and on, but I'm going to stop here and ask if you have any questions and or comments or anything you'd like to talk about.
If anybody has any questions, please put it in the chat or feel free to go off mute and ask Sai anything you like.
Hello, this is Derek Williams. Can you hear me?
Yeah, I can hear
Okay,
you.
great. Great. I'm a clinician here at Woodlands, 18 Sandalwood Circle. Michael, well, first of all, I thoroughly enjoyed this presentation. Thank you so much. Very insightful. In the beginning of your presentation, you mentioned you started calling out different counties, and I believe you said York County. What was that about? I mean, I got lost in that. What was
Understandable. I think Pennsylvania has 67 counties. What I was talking about, I think, is that, well, Philadelphia County, which is the same as the city, is known as a judicial hellhole because of high verdicts. That phenomenon is spreading to other counties in Pennsylvania, including counties that are semi-rural or suburban.
okay?
One example was York County, where there was a multi-million-dollar judgment against a neurosurgeon for an unheard of amount of money, at least in terms of York County. It was the highest jury verdict, I think, in the history of the county. That was, and don't hold me to this, I think it was about $28 million. So Philadelphia, if you're a defendant, may be the worst, but it's far from the only county where you're starting to see big verdicts come in. And there's no indication that that's going to lessen anytime soon.
Thank you so much. I am from South Carolina originally, and up here, and I'm in the York area every weekend, and was contemplating moving out in that area. So when I heard York, it just struck something. So thank you so much.
Well, I wouldn't not move there just because it has occasional high malpractice awards, but yeah, that was the point I was making earlier.
Thank you, sir.
Thank you.
Anyone else have a question for Sai? All right. Well, thank you so much, Sai. Great job, great presentation, very insightful. If anybody would like to see the presentation, we will send that out to all of the registrants so you can see it and get some more insight, and feel free to ask Sai any questions directly. Thank you, everyone.
Thank you, everybody.